Hereby, I open this academic ceremony in which Sander Kramer will defend the academic thesis entitled Effective Cross-Border Pension Information in the Face of Multi-Level Legal Systems, a cross-disciplinary research into the cross-border taxation of pensions. And I welcome everyone present here in this aula and everyone watching this ceremony online. Dear candidate, may I please invite you to present a summary of your study and the conclusions of your thesis.
Thank you, Pro-Rector. Dear Pro-Rector, dear family, friends, colleagues, welcome to the public defense of my dissertation entitled Effective Cross-Border Pension Information in the Face of Multi-Level Legal Systems. I think the topic of my dissertation concerns us all, pensions and taxes. In the next 15 minutes, I will present a brief summary of the findings of my dissertation, but let's start by addressing the problem statement, the predicament we're all facing. Why did I conduct my research? From a macro perspective, we've seen that in recent years, European member states' pension systems have been reformed structurally and in a fairly rapid pace. The predominant element in these reforms is the shift of defined benefit schemes, under which a defined benefit is granted, to defined contribution schemes, under which only a pension contribution, is granted to pension participants. Throughout these developments and reforms, we've seen that the responsibility for an adequate pension lies more and more with the participants themselves. Yet, instruments and measures for these very participants to cope with these increasing responsibilities are still lagging behind. They're missing. This is reflected in the information asymmetry between the pension sector and pension participants. I therefore argue in my research, and that is the central presupposition, that effective cross-border pension information is at the very center of enabling people, especially mobile pension participants, to secure an adequate pension which corresponds to their earned income during the accrual period to enable them to better assure it. Cross-border pension information is gaining importance more and more since mobility across the European Union persists to increase. It's reflected by the numbers. For instance, in 2019, there were over 17 million mobile EU citizens. So imagine, for instance, someone who first lived and worked in the Netherlands, then moves to Germany and to work there for a couple of years, and eventually moves to Belgium. Accordingly, in each of these residence or working state, he or she has accrued some pension entitlements through different pension systems, schemes, products, accrual methods, vesting methods, and of course the tax treatment. It is my point that these persons should be provided with an aggregate pension overview, covering all their dispersed pension rights, supporting them in planning for an adequate retirement. I think it deserves not too much explanation that providing these mobile citizens with such a pension overview is tantamount to solving a Rubik's Cube, where all pieces, so legal systems, pension systems, are intertwined. In this regard, cross-border pensions are marked by a couple of features, characteristics. First, a dispersed accrual of pension entitlements across numerous states and pension systems. Secondly, diverging national systems in terms of pension pillars, accrual methods, pension schemes, vesting methods, and tax treatment. Intersections between different levels of multi-level legal systems, so national law, EU law, and international law. And fourth, I should say, interaction of poorly coordinated legal domains, so pension and tax law. So converging all of this legal reality into standardized pension information makes us aware that one size certainly does not fit all. So how did I conduct my research? Basically, my research consists of three parts. In the first part, so the upper circle, I have explored what the provision of effective pension information entails, And I established an evaluation framework based on insights from behavioral economics, economic psychology, and cognitive psychology in order to allow me to evaluate the legislation's fitness, so to say, the suitability. In the second part, the circle at the bottom, I've compared the regulatory frameworks on a national, European, and international level concerning the tax treatment of statutory, first pillar, occupational, second pillar, and personal pensions, third pillar, in cross-border situations. And where emphasis was put on the bilateral relation between the Netherlands and Germany. In the third part, so the bigger circle to your right, I've provided recommendations on what legal and non-legal interventions were needed to ensure and potentially foster the effectiveness of the information provided. This brings me to the term effective. What is effective? I perceive the notion of effective pension information as a two-dimensional construct. First, at the heart of this figure, the center of this figure, information should comply with a so-called behavioral purpose, which tells us what should people be able to do based on the information. This, however, does not tell us how information should be provided. Therefore, in my opinion, information should also comply with 4 other criteria drawn from dual process theory, thinking fast, thinking slow. Information would therefore be understandable, legally correct, trustworthy, and personally relevant. Moreover, as part of my dissertation, I've conducted an experimental study which revealed that pension participants have a preference to be informed about future pension in net amounts, so after taxes, enabling them better to compare it to their current net earned income. However, this two-dimensional notion of effective pension information did not allow me to evaluate the regulatory framework's fitness in legal terms. Therefore, I adopted a distance approach and translated this notion into 4 principles, along which I was able to evaluate the regulatory framework's fitness. These 4 principles were similarity, or to a lesser degree, comparability of legal systems, inter-level coherence between the different levels of legislation, inter-system consistency between 2 legal systems, and the foreseeability of legislation in the future. So along these 4 principles, I've come to my recommendations and my findings. When it comes to similarity or comparability, I found that regulatory differences, a lack of harmonization or coordination, and complex interactive processes are the most prevalent obstacle when it comes to providing effective pension information, since it hinders us in putting the puzzle together. For instance, I found that although there is some consensus to divide pensions into 3 pillars, first pillar, second pillar, third pillar pensions, a universal agreed taxonomy, classification, or definition is still missing, it's lacking. In order to adhere more to this principle of similarity comparability, my point is that the interdependence of the various legal systems should be ensured more. This can be achieved by abandoning an isolated approach and incorporate foreign tax law more in the development of national tax law. So to put it simple, we should look across borders. In conclusion, when it comes to this principle, I found that the legal toolbox falls short of instruments to mitigate the lack of coordination or integration between national legal orders. When it comes to intersystem consistency, we see that this requirement is not deeply rooted in national, nor in European, nor in international tax legislation. The comparative findings reveal a wide range of situations where applying national legislation leads to incompatible outcomes for a specific case, specific in terms of comparable situations. For instance, I found that German legislation of tax law is applied on the basis of an isolated approach, so without taking into account any foreign tax relief that may be granted previously or subsequently. It is my recommendation that Germany should abandon this isolated approach and expand the determination of the tax treatment by incorporating foreign tax law more into German tax law. So specifically, the Einkommensteuergesetz. When it comes to interlevel coherence, I found that the European Commission seeks to find a balance between subsidiarity, national states' tax sovereignty, and a more coherent European approach. I find it remarkable that since the 2001 communication, the Commission has taken no considerable steps in the sphere of positive integration, while persistently relying on three principles: no harmonization, no discrimination, and no tax revenue shortfall. The Commission's narrow approach of leaving the development of a coherent approach to the Court of Justice case-by-case interpretation and the autonomous reaction of the member states lacks decisiveness. The discussion should focus on whether it is necessary to develop certain measures of secondary EU law, so positive, or soft law, and the content of these measures. Moreover, I strongly believe that the delimitation of the tax regimes for supplementary pensions should not be just left to the development of the Court of Justice case law, since this may lead to a tangential paradox. In conclusion, it is my recommendation that the Commission should move away from a narrow approach, update the 2001 communication, and urge member states to abandon the isolated approach and look across borders in terms of the tax treatment of cross-border pensions. When it comes to international tax law, so tax treaties, it seems that these regulatory frameworks fall short of achieving more interlevel coherence between the different levels of legislation. This is so because tax treaties are built on political compromise, are reactionary, customary, and historically in nature. Moreover, I found that they originate from existing domestic laws and treaty practice, which still largely dictates the direction of their development. So there is no overarching concept of how all pieces of national legislation should fit together. As regards foreseeability, we cannot rely simply on the maintenance of the current law in force. Legislation changes. Tax law and regulations are attuned to social reality, so it reflects the status quo of society, economy, and politics in all its facets. Of a more technical nature, it can be said that national tax law is responsive to developments in the areas of positive integration, so undertaken by the European Commission, and negative integration, undertaken by the Court of Justice. Moreover, specific case and condition particular complex rules, which is typical for the domain of cross-border pensions, often lead to uncertainty, especially as regards their application. When it comes to the foreseeability of tax law, it should be pointed out that in general, tax law is less receptive to embedding morality. As moral imperatives alter at a fairly slower pace, it seems that tax law largely lacks moral legitimacy. Therefore, it seems that tax law is less predictable because it lacks a certain compass of stability based on these moral imperatives. In the vein of foreseeability, I found that the authorities, tax authorities, freies ermessen, can be considered to be at the center of unforeseeability. This refers to the tax authorities' competence to act within certain boundaries at their own discretion. This discretionary margin induces complexity, uncertainty, and a lack of foreseeability of rules and regulations. Furthermore, my research revealed that citizens have not yet been put at the center of law and policy making. Rather, we see that law and policy makers still seem to hold firm to a system's reality instead of a citizen's perspective. I would like to take the stance in my research that citizens should be put more at the heart of law and policy making on a national, a European, and an international level. It remains underexposed that tax legislation also constitutes a domain of behavior, heuristics, and biases. In conclusion, I found that the paradigm of drafting laws and policies is dominated by the paradigm of legal legitimacy. Elements of psychological legitimacy, such as understandability and trust, should be more emphasized and incorporated in the process of legislation. What is more, my research revealed that the domains of pension information and law and policy making appear to be separated spheres, where there should be rather interconnected vessels. Primacy still lies with legal principles, while incorporating empirical insights from other scientific domains renders these regulatory frameworks more effective and more resilient. This could be achieved by departing from a theoretical assumption approach and move towards a more empirically informed approach, which creates a more robust link between the law and the real world. From a scientific viewpoint, I believe that meaningful scientific and methodological innovation calls for exploring and in particular exceeding disciplinary boundaries. I am hopeful that these recommendations will find their way to the relevant stakeholders at all levels, so that eventually those who need effective pension information most, so European mobile citizens, shall be helped in planning for their retirement. This brings me to the end of my presentation. I hand the word over to the pro-rector.
Thank you so much for your presentation. The opposition will be opened by Professor Luja. Professor Luja is Professor of International Comparative Tax Law at our university, and he's also the chair of the Assessment Committee.
Thank you, Mr. Pro-Rector. Dear candidate, first of all, let me congratulate you for writing this explicit tome. Nearly 800 pages, 3,000 footnotes, and this is already a more concise version than the one we had to read. So my compliments on that. Let me say it's also necessary to be more than average, because you are combining law with behavioral sciences in the broader sense. It's something that we need to do more, this type of research. And yes, of course, you had a lot of explaining to do to all those lawyers who tried to get some grasp on what behavioral sciences entail. So half of this is really for people without that background. So it's a necessity to have something like this size, even though 200 pages less wouldn't have mattered, I think. That said, your remarks in your opening presentations about taxation lacking morale, about limitations of vrije zamessen, they already incline me to change the question that I wanted to ask, but I will not do so. Maybe when I get a later chance, I'll come back to that. But just yesterday, my son was sitting in the living room. He was looking at YouTube. He had a Minecraft video, and in the middle there was a commercial. Commercial said, "You're never young enough to start thinking about extra pension on retirement." He was 10 years old. And then then they said, "You know that you get a lot of tax benefits if you do, so think about it." So tax benefits were the trigger to think about extra income for retirement. My son looked at me with questioning eyes for a second, and looking at your book, which I had at the table at the time, I thought, no, I'm not going to explain that. But I was wondering, the average adult who sees the same commercial, even if you're not working cross-border, may already have questions about the status of his retirement stage and the income he can expect. In cross-border situations, you rightly focus on a situation where this is even more difficult to get a real grasp upon. And this is, of course, what my question will be about. On page 11, in the opening, where you state the objective of your thesis, one of the things you say, we want to see whether the systems are fit to provide effective pension information, which is about net amounts of pension. So what can people really expect net in their personal situation? Which is, of course, what people really want to know in the end, or at least that's something they should be aware of. But only on page 73, so just 60 pages later, you already conclude, and let me quote, "The understandability requires that specific personal circumstances and particularities shaping a taxable person's financial position should be left out at the expense of the information's personal relevance. In practice, a balance must be struck so that the information is as precise as possible while remaining sufficiently easy to understand." So while you say people should have as much net information, you also say there is a natural limit. Now, you keep repeating this, that of course there is this need to find a balance, but in the remaining 700 pages, I didn't see you telling us where the balance lies in your view. And that is my question. If on the one side you say you need as much net information that you can have, and on the other side you say there's a necessity to limit the information, where would you find your balance? I look forward to your answer.
Highly esteemed opponent, thank you for your question. Let's start by saying that my son is 3, so his pension awareness is even lower. Let's start by saying that the principal objective of my research is to evaluate the law's fitness in order to provide effective cross-border pension information. Then, of course, the question comes up, what is effective? Which I perceive as at the heart of the figure on the slide, that it should comply with a certain behavioral purpose. That behavioral purpose tells us what people should be able to do based on the information. That very behavioral purpose can be established by using the functional analysis, keeping in mind what is the target group, what is the cognitive effect, and what is the subject matter. This behavioral purpose can be established by using the functional analysis, as I already mentioned, and it's developed by Lens and Pandelmaat. So that is at the very heart of what is effective. Then the second question is, the behavioral purpose does not tell us how information should be provided, only what information in order to adhere to the behavioral purpose. So secondly, effective cross-border pension information should be understandable, legally correct, personally relevant, trustworthy. Where the balance is found, and that is what I also mentioned in somewhere of these almost 700 pages, is that where the balance must be struck is a decision that is up to the information providers to determine. Whether it should be more understandable than legally correct, so leaving all details out, making it more understandably and maybe, I guess, less legally correct. Should it be more trustworthy? Should it be more personally relevant? Where to find the balance? That is up to a decision to make on a more policy level. It was not my purpose to determine where the balance should be struck. I only provided recommendations that when it comes to the legislation's fitness, I see that there is certain room for improvements. When it comes to the relation effective and net, there can be a stepped approach. First, behavioral purpose. Second, it should comply with the 4 principles. And third, it should be net indeed. Because I've conducted, as part of my dissertation, an empirical study exposing people to either net amounts, gross amounts, or net amounts accompanied by a disclaimer, trying to unravel what the effect of those 3 text frames were on 5 dependent variables. Ease of comprehension, which is equal, in my opinion, to understandability, informativeness, trustworthiness, expected financial future security, and behavioral expectations, not intentions, but expectations. As I also elucidate in the conclusion of chapter 1, I see that the discussion on the behavioral purpose and the 4 principles is the framework specialis, and that when we look more specifically, so not how information should be provided, but how these amounts should be provided, so this very amount, because what is pension information? It can entail elements about pensionable age, vesting methods, accrual methods, and so forth. But when it comes to pension information, enabling participants to ensure their adequate income, it is my opinion that at the very heart of that information is the future pension income. And the findings when it comes to net income, I see as the lex specialis, which can be taken into account when trying to find a balance in the equilibrium of those 4 principles.
Thank you for your answer, but I'm not going to let you off the hook this easily. Just one short follow-up question. If you're lucky tomorrow morning, you're Dr. Kramer, you're the one who is the expert, and all those people, those information providers will look to you for your recommendation on finding the balance. You not just shifted that responsibility to those providers, but what would be your recommendation?
Highly esteemed opponent, that's a tricky one, because as I already mentioned, I'm a scientist, and I do not see myself competent to make more policy-oriented decisions. What my recommendation would be is at first, and that is what we see in practice is still lacking, to adopt this empirically informed approach in which we adopt and include all relevant findings when it comes to how people see information, how they interpret information, what they believe, what they don't believe, how they interpret it. So I'm not going to say what should be prevailing more. It's up to the purpose. And it is my belief, and that could be my recommendation. If the purpose is indeed to ensure more adequacy, we should at first instance make sure that at first pension is understandable, because there's enough research in that we've seen that if at first sight, so prima facie, people see that information is not understandable because it is too lengthy, it's too difficult, and okay, my dissertation is not the best example of providing understandable information, I'm aware of that, but that understandability should be the first principle to be adhered, because, as I already mentioned, it's pivotal.
The opposition will now be continued by Professor Stevens. Professor Stevens is Professor of Social Law at the University of Leuven, and he's also a member of the Assessment Committee. And I would like to welcome Professor Stevens very much to Maastricht University today. Very good to have you here with us. Please.
Thank you, Mr. Chair. Dear candidate, dear Sander, what a great read. In all honesty, it's one of the best books I read in the last years. And more in honesty, I wish I was the author myself. Sander takes the author throughout the book and leads the way forward. This is the type of research we truly need. In short, this thesis takes the reader into a wonderful journey in the comparative pension landscape, whereby an easily readable and accessible analysis is provided on the interaction between the fiscal landscape in the Netherlands and Germany and the right to information on behalf of the participant. The thesis was for me a real pleasure to read. It's an ideal Christmas present, by the way. In the true meaning of interdisciplinarity, the defendant combines law, economics on the relativity bias, I learned a lot, sociology on the experimental measures, chapter 3, the best chapter in my opinion, philosophy on the morality of tax law, and even psychiatry on the expected future financial security. When reading the setup of the research, I have to be honest and say I was really skeptic in the beginning. I had my doubts on the feasibility of such a project. However, it needs to be said, the defendant does succeed in the setup he made. He combines the conceptual framework of different pension types with both fiscal structures and the information requirements. The strong point is, in my opinion, the blend of the conceptual theoretical framework of pensions, the tax system, and the information requirements in a multi-layered setup. Especially the chapter 3 on the net amounts was an eye-catcher for me. The problem with the net amount is, in my opinion, countered by the problems with the overall unpredictability of the legislation in general. In my opinion, again, these connective dots make the work truly, truly good. For example, how can you be certain on the information on your net amount when over time the tax legislation is truly unpredictable? We all know we cannot give any sound judgment on this, but the defendant explains in detail what the mechanisms are behind these reasonings. Sander, this is my 6th thesis this year. The better the thesis, the tougher the questions. So here we go for a very tough, provocative question, and I know you can do it. I choose a very provocative question, and more specifically on your presupposition of the enablement of an adequate pension. Sander, what is the use of pension information if you cannot alter the or your own situation? Whether you know nothing about the AOW and the occupational pension, or you know everything about the pension systems, you know all the ins and the outs, it doesn't affect one bit on how much pension you will receive. In your answer to Professor Luya, you said, well, information should be effective. But isn't this entirely irrelevant? Net or gross amount, you cannot change the system. An individual cannot change the tax system on its own. Any citizen must endure the pension system, must endure the tax system. So whether you know a lot or you know nothing, in the end, it doesn't matter. It is how it is. Unless the only way forward is to say to people, look guys, you have to save more for your pension. And then you get commercials on the television saying that you can tax discount. So my question is, isn't financial literacy and pension information, seen from this perspective, just one big hoax of the financial sector?
Highly esteemed opponent, thank you for your indeed provocative question. When you say that it is how it is, that is one of the fundamental predicaments, problems I saw myself faced with when we look into the fitness of the regulatory frameworks through the lens of effective information. It is how it is. We should deal with the legislation how it is right now. When it comes to, and I see certain elements that I want to address in your question, when it comes to adequacy, what is an adequate pension? There's a lot of research being done on what is pension adequacy. Is it only the replacement rate between earned income and retirement income? Is it also, as advocated by Michael Visser, should also be an element of sustainability be included in what is an adequate pension income? And even the Court of Justice of the European Union ruled in a very recent ruling of the 16th of November on the infringement procedure against the Netherlands on capital transfer, that it cannot be said what a adequate, I translate this as adequate because the only version now available is either Dutch or French, and in the Netherlands they refer to goed pensioen. And if I would translate it into English, it refers to adequate pension. And the court holds that if we look at the European rights systems, it cannot be said what is an adequate pension. So that is the first predicament we're all facing with. And what I find a very interesting research avenue for future research. By the way, the court also ruled that the fact that we cannot establish what adequate pension is cannot be brought forward as a justification ground for discrimination. That about pension adequacy. What my very point is, and what I referred to in chapter 1, is that at least we can see effective pension information as a first step. Effective entails the behavioral purpose. The behavioral purpose refers to target group, cognitive effect, and subject matter. And that allows us a certain leeway to adapt information in terms of effectiveness to what we need. If, for instance, we want that information provision increases pension awareness, then we have the instruments based on my dissertation to adapt the behavioral purpose and make sure that based on the wide body of literature that is still available or is available, that we can increase pension awareness. Indeed, most people in the European Union and international have very, very little knowledge about their pension. Nevertheless, we've seen that also from a policy perspective, we move from the theoretical assumption to more empirically informed, and that we adhere more importance, more and more to that very pension information provision. We also see that the European Commission, for instance, has moved throughout her communications from 1991 up until 2010, where she says that in the 2010 communication, more importance should be placed on information provision. So at least we see that information provision, providing information on the legal systems, is gaining importance more and more. So that is certainly a development that can be welcomed. The element whether effective cross-border pension information is enough to improve pension adequacy, there are a lot of elements that still need to be taken into consideration. First, the behavioral purpose. Second, the 4 principles. And whether it will be sufficient. I'm hopeful, but I guess we'll have to see. And I hope that that a bit at least answers your question in terms of the elements you referred to in your question.
Thank you. Thank you, Mr. Chair. No further questions.
Thank you so much. The opposition will now be continued by Professor Staring, who is Professor of Labour Market, Pensions and Taxation at the University of Tilburg, and who is also a member of the Assessment Committee. And I would also like to welcome him very much to our university here in Maastricht today. You have the floor.
Thank you very much. Dear candidates, let me also begin by offering my sincere compliments for your dissertation. It has become a substantial and well-researched book that has sparked even more interest and enjoyment in an international pension enthusiast like myself. It's also a very dangerous and lethal book. It is so thick that if you would hit someone on the head with it, he would die. Although the subject of cross-border pensions and taxation is not new to me, as you know, the combination with effective pension communication is indeed new. I appreciate the multidisciplinary nature of your research. There are logically at least two things needed to enable effective pension planning for individuals who have built up pensions in multiple countries. One is, of course, an adequate pension, linked to the discussion we just had, and the second one is, of course, insight into it. And the latter is often lacking. That's what you mentioned. But in addition to creating insight through effective communication about pension accumulation in multiple countries, there may be an even more effective way to solve this problem, at least for occupational and personal pensions. And that is enabling the consolidation of all pension entitlements into one pension claim or one pension fund, basically meaning the transfer of capital. And that brings me to my first question. In chapter 8.5.1, you state that, among other things, based on the judgment of the European Commission of Justice in the case Commission versus Belgium number 2, an international transfer of pension capital is in violation with the European freedoms if it results in taxation when a national transfer does not. However, as you know, and the case was already mentioned in the previous question, the Netherlands disagrees, or disagreed, I don't know, but disagrees with that, disagrees with the Commission on this matter. In the case, recent case, Commission versus the Netherlands number C360/22, in which the court ruled on November 16, 2023, so just over 3 weeks ago, it is evident that the Netherlands takes the following position. And you're right, it's only in Dutch and French, so I did translate it for you. And I quote, well, I quote the translated version, and I used ChatGPT for that. The disadvantage for migrating workers is purely the result of a discrepancy between the relevant national regulations and the exercise of tax powers by the authorities of different member states, stemming from the fact that EU law does not harmonize pensions and taxes. As a result, member states are free to establish and maintain their own pension and tax systems, which may differ from those of other member states. Makes sense, right? Mm-hmm. But now the peculiar thing comes. If other member states were to provide the same possibilities for the redemption of pension entitlements as the Kingdom of the Netherlands, that disadvantage would disappear. Of course it would, right? Doesn't make any sense. Consequently, Dutch regulation in question does not constitute an obstacle to the free movement of workers. The court dismisses this position and sides with the Commission. My question is as follows. In your dissertation, you successfully argued that the enormous disparity in pension systems and tax systems makes effective pension communication basically impossible in cross-border situations. One solution could be to always transfer pension transfer pensions cross-border so that a pension is received effectively only from one EU member state de facto. In that case, the communication problem would basically be absent. So, my question is, don't you think that this is the solution to solve this communication problem? I would like to hear your thoughts on this, on the possibilities for this to happen, and why you agree or disagree.
Mm-hmm. Highly esteemed opponent, thank you for your question. I've indeed read the court's judgment and the very recital, so the court's ruling indeed surprised me too, because I've never seen it before that the court would argue such a point, or the Netherlands at least. When it comes to the cross-border transfer of pension capital, we've seen that since the 1991 communication of the European Commission points that it should be improved in cross-border cases, so the cross-border transfer of pension capital. Due to disparities, discriminations, there's a huge difference, so okay. However, in 2010, the communication of the Commission in 2010, we still see that seemingly the pension capital transfer across borders is still a problem. 2 weeks ago, EIOPA, so the European Supervisory Authority when it comes to occupational pensions, released its document arguing that IOP 2 directive should be revised. One of the arguments why it should be revised is that still pension capital transfer in cross-border cases is too difficult for pension participants, for instance, because 2/3 of votes are needed in order to approve the capital transfer. So, conclusion for that part is that it certainly has attention and that should be given more attention. Whether it's feasible, I'm a bit more pessimistic, because given the division of competences in the European Union, so when it comes to taxes, we perceive tax law as one of the last fields of national state sovereignty. When it comes to unanimity requirement, we could argue that unanimity requirement should be abolished and we should move to qualified majority of voting. When it comes to subsidiarity, we see that it is very, very hard to make national pension systems more compatible with each other and with the European treaties, so the Treaty on the Functioning and the Treaty on the European Union. When we see what measures we have at our disposal, so positive integration and negative integration, we see that the European Commission relies more and more on the instrument of negative integration, relying, in my opinion, too heavily on the case-by-case approach, the ex-tunc effect of the court's rulings. And my recommendation is that the European Commission should move away from relying too heavily on the European Court and update the 2001 communication. So instruments in terms of negative integration are limited, they are inconsistent, and they lead to a tensional paradox if we would rely too heavily on the court. Because the court states that tax treatment that is granted to domestic pension systems should also be granted to foreign tax assessments. That is what we refer to as a delimitation of tax regimes. We see that most states in the European Union adopted an EET system in which contributions are deductible. E stands for exempt. Second E, exempt, is that yields on investment income at the part of the pension fund are exempted.
Yeah, I know what EET means. So
okay, it was more for the benefit of the.
Yeah. But looking at the clock, I would like to.
Okay, so we rely that most states rely on the EET system. But if we would follow only the Court of Justice way of reasoning, that would urge member states to switch to a TEE system. Because forcing them in terms of soft law from switching, of delimiting EET systems would lead to a decrease in tax revenue, so tax revenue shortfall, presumably. So I see that both when it comes to negative integration and positive integration, I see that especially when it comes to disparities, and disparities are inherently a discrimination that can be justified because it follows from the difference between national tax systems. I'm very pessimistic whether pension capital transfer in cross-border cases can ever be resolved sufficiently.
Yeah, so if I understand you correctly, theoretically we agree that if this would be done, right, international transfer of pension capital, that would be the best solution to tackle the communication problem. However, it takes probably too long and is, in your perspective, unfeasible. So the second best solution is better communication.
Highly esteemed opponent, thank you for your follow-up question. I would not say that by transferring all capital, for instance, into a pan-European pension fund or PEP, the personal European pension, that would resolve all our challenges when it comes to pension information, because then still we have like this equilibrium between these four principles: understandability, trustworthy, personally relevant, and correct. Okay, it's all like merged into one system, but challenges still persist to exist. It would at least make it a bit easier, I would say, if pension capital transfer is indeed made easier. Because in my first chapter, I mentioned somewhere in one of the 3,000 footnotes that the problem of cross-border pension information can indeed be resolved when pension capital transfer cross-border is made easier.
Thank you so much.
Thank you very much.
The opposition will now be continued by Professor Werepas, who is Professor of Tax Aspects of Cross-Border Work and who is also a member of the Assessment Committee.
Thank you, Mr. Pro-Rector. Dear candidate, first of all, congratulations with your PhD thesis. It has become an extensive book, as I said already before, in which a comparison is made between the pension system of the Netherlands and Germany especially, which is not easy. So compliments. Your research makes clear that pensions are defined and implemented very differently in each country. So let alone that cross-border tax aspects are clear, especially for a single taxpayer. And it was so simple in the previous century. In the past, and I'm talking in the first half of the 20th century, it was much clearer when it came to taxation and cross-border private pensions. It was almost impossible to imagine, but in that time, the treaty between the Netherlands and Belgium did not regulate the taxation of private pensions at all. In those days, there were only a few tax treaties. In general, these tax treaties, they attributed the right to levy taxes on private pensions to a resident state, and a few treaties to the source state. And then there was even a special example. That was the treaty between Sweden and Finland. Maybe that's an interesting one. They said the right to levy taxes on pensions was attributed to the state in which the employment was exercised. So I want to elaborate on these principles, attribution principles you can call, because what you wrote about these principles made me curious. On page 663, and especially on page 785 in the Dutch version, it seems to be that there are the following sentences added, and I translate in English. That is why I argue for a reconsideration of the tax principles for the allocation of taxing rights in international tax treaties, where more attention must be paid to the coherence between the different levels, like national, European, and international. And my question is, which principles should be leading, according to you, regarding the consideration and the multi-coherence? You didn't mention this. And does it matter whether it is a first or a second pillar pension? And does it matter whether it concerns a contribution or a benefit? Perhaps, you might say, that cross-border problems of pension and the provision of correct information should preferably be solved bilaterally, so tailor-made perhaps. And finally, if you are going to answer this question, can you also take into account in your answer what you stated on page 788? Because that makes me curious. This is also in Dutch, I translated. With regard to international tax law relating to cross-border pensions, national treaty policy, the OECD Model Treaty, and the concluded treaties, there are no signs that other than the legal angle is being taken into account. But I have always understand, especially in case of pensions, that the budgetary element, the loss of revenue, was an important issue for states. And that is why there is a shift from the state of residence to the state of source. So I hope you can shed some light on these questions.
Hi, esteemed opponent. Thank you for your question. Again, quite a provocative question. I have to admit that maybe it was a bit strongly argued to say that we're rethinking the principles of tax law. What I did mean is that if we look at cross-border pensions, we still see in terms of interlevel coherence, so whether there is coherence between the national, European and international legislation, we still see that there is very little coherence. They operate separately. For instance, in the 1999 communication of the European Commission, we see that the Commission argues that solutions for cross-border pensions, and especially the tax treatment, can be found maybe not in a European approach, but in a bilaterally approach. Of course, the European Commission does not say anything how tax treaties then should be drafted or developed or whatever, because the European Commission is not competent to do so. And when it comes to the 1999 communication, the Commission refers to the so-called pension premium provisions in situations where, for instance, a cross-border worker residing in the Netherlands, moving to Germany, joins a German occupational pension scheme. It must be ensured, pursuant to the pension premium provision, that the contributions paid in Germany should be recognized, mutual recognition, to the same extent as they should be deductible in the Netherlands. So that is one of the approaches advocated by the European Commission. Whether that is successful, I'm quite pessimistic, because the Commission wrote it in 1991, and still we've seen that very little tax treaties incorporated such a pension premium provision. What I did see what I also found in the communication of 1999 is that the Commission argues that apart from the pension premium provision, member states should maybe move away from an isolated approach and move towards more kind of balanced method. For instance, Article 3.82 of the Wet Inkomstenbelasting, that pension benefits are only taxed when they exceed the fiscally facilitated pension premiums. I find those two approaches advocated by the Commission most helpful in creating a more interlevel coherence between European law, national law, and international law. So we've also seen that there is a move indeed from resident state taxation to source state taxation, which has been laid down by the Netherlands in de notitie fiscaal verdragsbeleid en by Germany in de verhandelingsgrondlagen. But rethinking principles of tax law was maybe a bit too strongly argued, in that ultimately, as also mentioned in my presentation, we see that tax treaties are historically shaped. They're based on the precise bilateral situation between two states. We can say very little about the outcome of treaty negotiations, because it is up to the treaty negotiators to, by give and take, reach an agreement, reach consensus. What points of fiscal treatment of cross-border labor, for instance, are adhere more importance to. So rethinking yes. Rethinking international tax law, yes. But being more open to approaches advocated by the European Commission. I hope that answers your question.
Thank you so much. The opposition will now be continued by Professor Post, who is Associate Professor of Finance at the School of Business and Economics of our university, and who is also a member of the Assessment Committee. And he is joining us online from Mexico. Professor Post.
Yes, hola. Dear candidate, dear Sanda, let me also congratulate you to a wonderful thesis you have delivered. Given the time, I have to limit myself in praising the work you did. But just reading one of the sentences I wrote in my assessment report that demonstrates a little this excitement I felt. So I write, this thesis is excellently demonstrating how much more we can learn and progress in science and lawmaking if we look beyond the barriers of individual disciplines. I mean, and I have a whole page of nice words about your thesis. I could go on, but cannot. Now, my question. On page 46, you write the following. The question arises why people even harness this philosophical route of tapping into simple cues, rules of thumb, and shortcuts. In order to function in contemporary society, people often are compelled to act as cognitive missers. Ideally, people would hold opinions merely pertaining to topics they have elaborated on effortfully. So basically, you argue we should use more cognitive thinking. Now, my question is, don't we have a contradiction here? So most heuristics very likely originate in an evolutionary process and selection. So if careful cognitive evaluation would be a superior strategy, why didn't it not win over the shortcuts? So the question is, what is so bad about shortcuts, or maybe when are shortcuts bad and when they are good? I look forward to your answer.
Esteemed opponent, thank you for your question. This question again concerns the equilibrium between two ways of thinking we see in how people think, how they perceive information, what do they consider important, which can be then divided in the conscious route and the subconscious route. At a lower level, we see that information can also trigger to elaborate more or less when they're exposed to information, what is referred to as the elaboration likelihood model. What we still see when it comes to policy is that policy is still based on rational choice theory. So presuming that people still act as fully rational human beings having full motivation, ability to think, to elaborate, and to read information. However, we see that the field of behavioral economics has disproved most of those assumptions when it comes to how people behave, how to read information. That is what we then refer to as heuristics, biases, and so forth. I think the principal bias in chapter 3 is the relativity bias, in that people are prone to making comparisons and making a decision. So if they are provided information of future pension, we see that they want to know how much they will receive.
You may briefly conclude your reply.
That we see that people want to make a comparison between what they earned and what they get in future pension income. What is best determines on the decisions made by those individuals based on that very information, whether it inclines them to employ the more the heuristics, the mental shortcuts, the biases. It has to be proved by eventually what decisions they make and what best cater their interests.
Thank you very much, Sander.
Sander Kramer, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company await the results of our deliberations and our return here in this room.
The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Southside, 10 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. On the line, I know you know that I can't read your mind. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile. Long road to the south side, 10 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off. Take the mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. It's a better future that we go for. And even though these nights seem long, I know that I am never on my own. Know you've won the battle once you've grown. To the south side, 10 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. Long road to the south side, 10 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. What's on the line? I know you know that I can't read your mind. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile.
Sander Kramer. The degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taken into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Bruggen is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Belooft u dat u altijd volgens de beginselen van wetenschappelijke integriteit te werk zult gaan. Eerlijk en zorgvuldig, transparant, onafhankelijk en verantwoordelijk.
Ja.
Krachtens de bevoegdheid, ons door de wet toegekend, volgens het besluit van de commissie hier tegenwoordig, verklaar ik hierbij u, Sander, Paul, Martijn Kramer, tot dokter te bevorderen en u alle rechten te verlenen die daaraan volgens wet en gewoonte zijn verbonden. Ten bewijze hiervan overhandig ik u nu de bul, door rector, secretaris en overige leden van de promotiecommissie getekend en met het grootzegel van de universiteit bevestigd.
Beste Sander, we doen het nu verder op het Nederlands. Gelet op familie, vrienden, collega's en iedereen hier aanwezig, denk ik dat het moment nou is om even naar het persoonlijke stukje toe te gaan. De zakelijkheid hebben we zojuist gehoord in een prachtige verdediging van jouw proefschrift. Bewust gekozen voor de Engelse taal, omdat we ook niet alleen maar in Nederland impact daarmee willen bereiken, maar juist ook in de buitenlanden, om het daarin verder te brengen. Maar goed, nu zitten we in het andere stukje, niet meer in de zakelijkheid. We zitten nu in het stukje waarvan we gaan genieten, waarvan we gaan vieren datgene wat je vandaag hebt bereikt. Ja, en waar zijn we begonnen? Het is al een tijdje geleden natuurlijk. We zijn hier vandaag samen om eigenlijk een heel mooi traject af te ronden, waaraan we zijn begonnen. Je was nog student en bezig met de afronding van je scripties voor de profielen indirecte belastingen en directe belastingen. Toen we samen aan tafel zijn gaan zitten, want ja goed, jij was wel geïnteresseerd in pensioen. Je had de blok pensioen bij mij gelopen, dus daar had je eigenlijk wel oren naar en je wilde wel weten hoe dat dan zat met zo'n proefschrifttraject en wat dat dan allemaal zo inhield. En nou, daar hebben we samen gezeten. Nou, en bij de startfase van Item hebben Lisa Brugge en ik ook al samen gezeten. En in die tijd waren wij eigenlijk al bezig met het Europese initiatief T-Type, Track and Trace Your Pensions in Europe. Waar wij eigenlijk zoiets hadden van, ja, daar moet iets meer mee gebeuren. Het is een goed initiatief, maar daar gebeurt nog wel wat. Er zitten heel veel dimensies in, heel veel dingen die belangrijk zijn. Maar ook de relevantie om daar veel meer disciplines in mee te nemen. En het niet, nou goed, wij item houden niet van silo-denken. En gelukkig zitten Lise en ik daar ook op dezelfde manier in. Want het is niet zomaar een technisch systeem opzetten met een koppeling van portals uit verschillende landen. Het is ook niet dat wanneer je in het ene land met pensioen hebt opgebouwd, dat je dan een stukje pensioen te zijner tijd in het andere land uitbetaald krijgt. En dat wat er dan in de portal staat, dat dan ook jouw netto uitbetaling is. Want daar komt die fiscaliteit waar je even doorheen fietsen. Hoe gaan we daar dan weer mee om met die grenzen en belastingverdragen? Aan de andere kant, dat kan alweer heel technisch bekeken worden natuurlijk. Maar goed, wat zijn nou eigenlijk ook weer de aspecten waar je mee te maken hebt? Want we zijn allemaal mensen onder elkaar, mensen van vlees en bloed. Dus hoe moet je dat dan doen als je van de ene kant heel fiscaal technisch met allerlei systemen bezig bent, terwijl je van de andere kant gewoon met de mensen van de dag te maken hebt? Hoe kunnen we dat nou doen en hoe kunnen we nou die componenten combineren? Nou, daar hadden wij, Lisa en ik, wel gedachten en ideeën over. En wij vonden in jou een zeer geïnteresseerde kandidaat die dat proefschrift, dat traject wel aan wilde gaan. Dus wij hebben wat dat betreft de start gemaakt. En oorspronkelijk hebben we dat ook heel enthousiast gedaan en heel enthousiast opgezet, met het idee dat we een 3-landen pensioenregister tussen Nederland, België en Duitsland gingen maken. En ons daarop oriënteren. Nou, na een tijdje zijn we er toch achter gekomen dat er zoveel speelde, dat het misschien toch maar verstandig was om de scope te beperken tot Nederland en Duitsland. Nou, gelet op proefschrift en de omvang die we vandaag hebben gezien, kunnen jullie nagaan hoe de omvang was geweest als we ook België toch hadden meegenomen. Nee, dus we hebben ervoor gekozen om dat te laten. Nou, je bent eigenlijk vanaf juni 2016 als promovendus bij ITEM begonnen aan dit traject. En nou goed, en zoals we dat bij ITEM doen, doen we dat ook met de voeten in het veld. Het is niet alleen maar de academische benadering, studies en theorieën. Je moet op onderzoek uitgaan en kijken hoe we op een bepaalde manier in de maatschappij een bijdrage kunnen leveren. En hoe je op die manier een stukje vooruitgang kunnen creëren. Nou, zo hebben we dus ook samengewerkt en bezoeken gebracht. Onder andere aan de Universiteit van Osnabrück hebben we de nodige gesprekken gehad en samengezeten. Waar we zowel ook wetenschap als verzekeringspraktijk en dergelijke bij elkaar hebben gebracht om te kijken, hoe zit dat nou, hoe speelt dat nou? Nou, daar hebben we ook koppelingen gelegd met onder andere de GDV, die in Berlijn zit. En op enig moment zijn Thomas Post, weliswaar nu in Mexico, hebben wij besloten om met z'n drieën naar Berlijn te gaan. Om daar in 2 dagen tijd bij de evenknie van de Duitse Pensioenfederatie gaan uit te leggen wat wij nou eigenlijk van plan zijn met dit onderzoek en wat we daarmee voor elkaar willen krijgen. En in Duitsland stonden ze nog een beetje aan de vooravond van een soort van pensioenregister. Dus zij wilden wel weten, hoe zit dat dan allemaal nou precies? Nou, Duitse ministeries hadden erbij aanwezig, de GDV hadden ook weer erbij aanwezig, verzekeraars. Nou, dus we hebben er inhoudelijk een hartstikke mooie dag van gemaakt. En toen we dus teruggingen, ik weet niet of je nog weet, hebben we dat op een hele turbulente manier gedaan in het vliegtuig. Want ik weet me dan nog te herinneren, het was de donderdag voor carnaval. Dat zijn voor mij altijd mijlpalen en die voor jou ook, waardoor je dingen heel goed kunt herinneren. Maar wij zijn op de donderdag voor carnaval in het vliegtuig gestapt vanuit Berlijn om terug te vliegen. Althans, wij dachten dat we zouden terugvliegen naar Düsseldorf, want daar stond onze auto geparkeerd. Maar net op het moment dat wij zouden landen boven de landingsbaan van Düsseldorf, was de wind en de storm zo heftig en zo hevig dat onze piloten niet aandurfden om te landen. Het was inderdaad, het bracht heel wat met zich mee. Hij trok stevig door op en we zijn doorgevlogen naar Keulen. En daar stonden we dan met onze rugzakjes, met z'n drieën. Nou, fijn, samen in Keulen, auto in Düsseldorf. Maar goed, we hebben er nog een Duitse passagier bij gevonden en we hebben de taxi genomen en we zijn teruggegaan. Dus, en op die manier, dat is de manier van het samenwerken die we altijd hebben gehad. We gaan de inhoud in, we zoeken de diepte op, maar we maken er ook hele leuke uitstapjes van. Het sociale, de component die we daarbij pakken. En waar jij ook graag een bijdrage aan levert om inderdaad daar plezier in te gooien. Dus, nou goed, dus we zijn op tijd in ieder geval terug geweest voor de carnaval. En dat is het natuurlijk ook. Hè. Het is niet alleen, je doet graag onderzoek, je doet ook heel graag onderwijs geven. Je brengt heel graag je kennis over. Maar je hebt ook tijd en wilt ook tijd hebben voor leuke dingen in het sociale leven. En los van het feit dat je af en toe alleen op je wielrenfiets stapt of met de saxofoon aan de slag gaat, is carnaval natuurlijk ook iets wat je heel graag doet. Ik weet in ieder geval de buurman aan de andere zijde die daar onderdeel van uitmaakt. Dus een carnavalsoptocht en dat soort zaken, daar doen jullie heel graag aan mee. Ik zal verder niet te veel uitweiden over carnavalsactiviteiten, maar goed, je viert hem graag. Maar goed, in de Tijba-item heb je op vele manieren dus je inspanning ook verricht naast het proefschrift door mee te werken aan projecten en het initiëren van ook een opleidingstraject waar we nu mee bezig zijn met de Universiteit van Hasselt. Maar zoals gezegd, je geeft ook graag onderwijs. Daar ben je al mee begonnen, al in 2016, met inleiding belastingrecht mee te doen. Je doet nu bij de kapgroep belastingrecht mee in het onderwijs geven. Maar je doet dat ook overzees, al is het online, door bij de Universiteit van Curaçao het internationale belastingrecht daarin over te brengen bij de studenten al daar. Maar goed, daarnaast staat jouw leven niet stil. Dus in die hele route die wij samen al hebben ondernomen. Zo staat Joyce al jarenlang naast jou, aan jouw zijde, gaat daarin mee. En ik vind het heel mooi dat ik op die weg, dat levenspad van jullie, daar een stukje aan de zijkant weliswaar, maar wel in mee mag doen en meegaan. En zo ook weet ik nog de hele blije aankondiging van dat Tijn in aantocht was, althans de kleine, dus op 21 augustus 2020 zijn jullie verrijkt met de komst van Tijn. En 2 jaar later heb ik met jullie bruiloft mee mogen vieren. Fantastisch om ook op die manier gewoon dat stukje in jullie privéleven, in jouw privéleven mee te mogen maken. Omdat we daar gewoon een hele fijne, mooie band in hebben. Wat ik enorm waardeer. En nu is natuurlijk de tweede opkomst. Dus een afwachting dat deze jullie gaan vergezellen. Jullie gezin gaat vergroten tot 4. Sander, ik kan nog wel heel veel vertellen. Er zijn heel veel leuke dingen. Maar volgens mij is het tijd dat we een beetje naar een feestje toe gaan. Ik denk dat je heel veel dingen mooi nu op de rit hebt. Ik denk dat je een heel rijk leven hebt, vol liefde, familie en vrienden om je heen. Dat je de balans daarin zoekt en er nou een beetje misschien nog net wat meer in evenwicht je balans weer terug hebt, nu proefschrift achter de rug is en de promotie verricht is en succesvol. Ik heb je leren kennen als een hele behulpzame, een hele vriendelijke, aardige student. Zo zijn we begonnen. En je bent geworden tot een hele fijne en betrouwbare collega waar ik heel graag mee samenwerk, wat ik heel fijn vind om te doen. Die af en toe last heeft van zijn perfectie. Maar dat juist ook weer jouw kracht is en jouw positieve kracht, omdat je je dan ook verdiept tot in de puntjes. En dat laatste, die mooie presentatie wat je hebt geleverd, en ook het feit dat je zo in de diepte gaat, zo grondig te werk gaat en de promotie, de proefschrift hebt opgeleverd, dat blijkt, en je hebt het me gisteren al trots even doorgegeven, maar als we dan kijken dat ons Europees parlementslid Jeroen Leenaerts jouw proefschrift al meegenomen heeft om in de uitzending op te nemen wat morgen uitgezonden wordt, om jouw resultaten aan te bevelen richting de Europese Commissie om daarmee aan de slag te gaan, dan denk ik dat je inderdaad wat dat betreft jezelf mooi op de schouders mag kloppen. Heb je een fantastisch resultaat geleverd. Maar goed, ik ga niet verder. Ik kan je nog blijven complimenteren. Je hebt fantastisch gedaan. Hartstikke mooi. Ik wil je van harte feliciteren met het hele mooie werk dat je hebt gedaan. En voor de hele fijne samenwerking die we hebben gehad. Ik hoop die nog lang te kunnen voortzetten. En voor nu wil ik je gewoon van harte feliciteren. En ook aan Joyce en familie en iedereen die je bij je hebt. En maak daar nou verder een mooie dag van.
Dr. Kramer, ook namens de Universiteit Maastricht en haar faculteit der rechtsgeleerdheid, van harte gefeliciteerd met de behaalde doktersgraad. Het is altijd heel mooi om te zien wanneer iemand zowel de bachelorgraad als de mastergraad als de hoogste graad die we beschikbaar hebben, de doktersgraad, haalt hier aan onze universiteit. Van harte gefeliciteerd. Ook veel felicitaties aan de beide promotores, aan alle familie en vrienden en aan Joyce. En uiteraard ook aan de paranimfen die, en dat verdient ook nog vermelding, tijdens de hele verdediging ook achter je bleven staan, ook op een letterlijke manier. Veel dank daarvoor. Ik heb één praktische opmerking en dat is dat er straks na afloop van deze academische ceremonie een receptie zal plaatsvinden. Iedereen hier aanwezig is van harte uitgenodigd voor die receptie namens de jonge dokter. Wij zullen nog heel even achterblijven hier in deze mooie aula om de traditionele foto te maken van de jonge dokter met paranimfen en met de commissie. En we doen dat hier, zodat ook professor Post op die foto kan worden vereeuwigd. Maar verder is iedereen in de zaal, behalve familie en vrienden op de eerste rij, iedereen al van harte uitgenodigd om alvast ook naar de receptieruimte toe te gaan. En daarmee, nogmaals van harte gefeliciteerd, en daarmee sluit ik deze academische zitting.
Echte paranimfen, inderdaad.
Dat is vrijwillig hoor. Ja, hier zo. Een beetje hier staan.
Ja, sorry.